represent the plaintiffs. Thank you for your time. I want to start out, Your Honor, respectfully, Your Honors, respectfully reminding you of two things. Number one, this is before this court on an appeal from a summary judgment. And as this court has said many, many times, I have reference to a 2021 case, United Steel Paper and Forestry, in which the court said that summary judgments, in reviewing summary judgments, we review the evidence in the light most favorable to the non-movement, drawing all justifiable inferences in the non-movement's favor. Which brings me to the second thing I respectfully remind you of. This is a redhibition case. This is not a case under the Louisiana Products Liability Act.
Why did you choose to bring it under redhibition as opposed to product liability or negligence?
Because an action brought under the LPLA regarding a medical device is preempted by federal law. Plaintiff cannot bring a products liability case in state court which involves any medical device that is approved by the FDA. That field is totally preempted by federal law. So it was redhibition or nothing.
I guess you could, I don't know the facts of the case well enough to say this, but you could have sued the doctor himself for negligence.
Your Honor, there was no evidence that the doctor did anything wrong. That wouldn't have been right. You can't do that. But we sued in redhibition because, sir?
Go ahead.
We sued in redhibition because redhibition is perfectly applicable to this case.
Well, counsel, redhibition is a creature of Louisiana contract law.
Yes, sir. That's correct.
So that would foreclose implication of res ipsa, which seems to be much of the argument that you've made with regard to the defect. Am I correct?
That's all of the argument, Your Honor.
But res ipsa is a negligence doctrine.
The LPLA is a delictual thing, and it revolves around fault. Redhibition is contract. It's under the law of sales in Louisiana, and it's specifically under the warranties of the seller. The seller warranties to the buyer that the object of the sale is fit for its intended purpose. If that object fails in normal use, Louisiana law says there is a presumption that the item was subject to a manufacturer's defect. Article 2545 of the Louisiana Civil Code says that the manufacturer is conclusively presumed to know of the defects in the thing he manufactures. So once we get into redhibition, and I'm going to refer back quickly to summary judgment. Summary judgment says that the non-movement, that was us, is entitled to all justifiable inferences. This court has said that a zillion times. The United States Supreme Court has said that a zillion times. All justifiable inferences. Redhibition does not create an inference. It creates a presumption. And in my mind, anyway, I think a presumption is stronger than an inference.
How would you distinguish that Grenier case, if I'm pronouncing it correctly? Grenier versus Medical Engineering Corporation?
Sir, I didn't hear you well. I'm sorry.
How would you distinguish? There's a case that's in the materials, in the briefing, called Grenier, Grenier, or Grenier versus Medical Engineering Corporation.
I believe I discussed that case, Your Honor. If memory serves me right, that was a combination case, and the district court held that the action in redhibition had prescribed, and that so that it was LPLA or nothing. And LPLA, when it comes to medical devices, is essentially nothing. So I believe that that case is distinguishable because the claim and prescription prescribed, and I think I discussed it in my reply brief, Your Honor. where the rubber meets the road in this case is that the defendants have argued, and the trial court adopted the argument, that the plaintiffs had to prove why the cement was defective. In an LPLA case, it's true. In a retribution case, it is absolutely not true. There are federal cases, state cases, that say in a retribution case, the buyer does not have to prove why the defect occurred. They merely have to prove that the object failed in normal use, absent any intervening force, intervening event, misuse, abuse. There is a presumption that it had a manufacturer's defect. In this case, the defendants acknowledge in brief and have not pled any intervening event, any intervening force, abuse, or misuse. So it is acknowledged, I think, as a matter of law, that the device, the cement, failed in normal use, which creates a, sorry.
Don't you also in retribution have to show that the defect was hidden? Isn't that a requirement of Louisiana?
Your Honor, the law on that is that, and this I believe is a provision of the Civil Code, says that a defect which is readily apparent on reasonable inspection is not a redhibitory defect. The cement in question was put in Miss Phillips' leg when she was unconscious. It was then sewed up. It was not removed until she was unconscious again when they took the first knee out and put the second knee in. So I would suggest to Your Honors respectfully that there was no opportunity for reasonable inspection. She never saw it. I mean, she was unconscious when they put it in her leg. That defect cannot be apparent because it is not available on reasonable inspection. She never saw it. It is and there are cases cited, I believe one of them is Young versus Ford. When you have a complicated thing like an automobile or a computer, or in this case, a very scientific cement made for a specific purpose to glue artificial knees to the bones of the patient, I could look at it, she could look at it, it looked like glue to me. Dr. Trenton used it, he installed it, it looked good to him. So I don't think there was any apparent defect in the cement. The cement simply did not work. In brief, and of course...
Well, the district court held that the failure of the cement was a known risk. In other words, that it was not hidden. Is that right? Is that what the district court said?
That's what he said, but that's the wrong law. That's LPLA.
Right. Well, but you, as I read your opening brief, you don't raise an appellate issue on that, do you?
Your Honor, I apologize for my poor writing skills. It has been my intention throughout this whole appeal to try to distinguish for this court the difference between LPLA and retribution. The district court's opinion involved numerous elements of the LPLA. For instance, he held that the plaintiffs had the burden to offer expert evidence as to why the cement failed. That is true in an LPLA case. That is absolutely not true in a retribution case. He held that Ms. Phillips received adequate warnings that her knee could fail. That may be pertinent in an LPLA case. It is absolutely not pertinent in a retribution case. The only defenses to retribution, are an apparent defect, use beyond its normal intended purpose, or abuse or misuse. Once the sale occurs, once you have a subject, once you have a sale, you have an object, and you have a failure in normal use, Louisiana law creates a presumption. Now, at trial, there's a lot more involved in that. We're talking summary judgment. What I am arguing is simply that the district court failed to afford the plaintiffs the benefit of a legal presumption that is set out in the civil code and in cases in Louisiana for 100 years. The buyer does not have to prove why the object of the sale failed. He only has to prove that it failed. Once he proves it failed, the buyer is entitled to a presumption. The district court should have given us the benefit of that presumption. That's the crux of my argument.
In other words, the benefit of the presumption would have precluded summary judgment.
Yes, sir. Yes, sir. Now, if the defendants choose to come back and plead abuse or misuse or intervening force or some use beyond its intended purpose, they are certainly entitled to do that. That is a good defense in a retribution case, and we'll deal with that when we get there. We're talking about summary judgment, and we're talking about a legal presumption that, as I said, I know it's been around 100 years. That's even before I started practicing law. We didn't get the benefit of it. The law says that the presumption exists. Defendant's brief and the ruling of the district court were full of elements attributable to the LPLA. Warnings, expert evidence. We did, at one point in their brief, the defendants exactly tracked the provisions of the LPLA, saying that we failed to allege that all the cement was bad, or that all the cement failed to meet FDA requirements, that the warnings were bad. All of that is applicable to LPLA. This is a contract case. Either they performed their contract or they did not perform their contract. Fault doesn't have anything to do with it. There's no fingers to point at anybody. Either the cement worked or it didn't work. In our case, the second doctor, Dr. Randall, said specifically 3 times in his deposition, and I quoted each quote both in my original brief and in the reply, that the cement failed to bond between the device, the knee device, and the tibia bone. It simply didn't bond. He didn't know why, couldn't tell us why. He said, but when he lifted it out, it came out smooth and clean, that there was no adhesion between the device and the tibia bone. So, and that gets me to the last element, which is that of cause. Dr. Randall said that he had to replace her knee because of micro movement. Her artificial knee was moving on the bone, which was causing her loss of use, inconvenience, loss of function. He had to replace it because of micro movement. The micro movement occurred because the cement did not work. In the simplest possible terms, but for the failure of the cement, she would not have needed 2 more surgeries.
As a matter of just personal interest, did he fix it so that she did have an operable knee?
Yes, sir. Now this is in the depositions, it's not in the brief, but she, because of all the surgeries on her knee, she has problems with scars and stuff like that. He's had to go back in another time and clean the scarring out. But she does have good fixture between the second knee and the bones at the top and the bones at the bottom. So they cured the cement problem. The other is just a result of having numerous surgeries.
Apparently, did he use the same cement?
He does not use bequeath cement, he uses another kind.
Hey, pardon?
He didn't use this cement, he used another kind, and I don't think he used the same kind of knee the second time. I'm not certain, I think my light's on, I need to.
Yes, and you've saved time for a vote. Thank you, Mr. Wilson.
Yes, sir, I'd like to save a little bit.
Yes, you have saved 5 minutes. Okay, Mr. Sarver?
Good morning, Your Honor. May it please the court, Richard Sarver and Sean McFall for the appellee. Let me start by saying Judge Doty got it right. The district court's opinion is entirely right. I'm not sure there's very much that I can say that will improve upon it, certainly not improve upon it, but perhaps clarify some of it. I have to start by responding to appellant's argument. What seems to be happening is a confusion that attempts to substitute a non-existent presumption in the law that doesn't exist in the law. You didn't hear Mr. Wilson cite to you any specific provision that said what he told you, that there is a presumption that if a product doesn't work as it's expected in its normal use, there is a presumption of a defect. I would challenge him to cite that because that provision doesn't exist. What the code does under the Article of Redhibition, Article 2520, 6 times in the article, it uses the term defect. In every element of proof that the appellant had the burden to prove, the term defect is used. What the plaintiff failed to do is provide any evidence in this case of an essential element, which is defect. Every single redhibition case requires a proof of defect. If we go to the Grenier case that was authored by Your Honor, Judge Jolly, plaintiff or appellant's counsel is simply wrong in his analysis of why that case was resolved. Redhibition and the LPLA were both involved in that case. It was a breast implant case where the silicone implant was removed, and in the course of removing it, there was something called silicone bleed found in the cavity. The LPLA case went forward, and the redhibition case went forward. The district court below did, in fact, dismiss the case on prescription. On appeal, Your Honor found that, yes, the district court was wrong on prescription, but you upheld the summary judgment because the plaintiff failed to provide any competent evidence of defect. And that is exactly on all fours with this case. Plaintiff has, throughout this case, provided 0 evidence that the cement was defective. There is no evidence in the record. I'm sorry, Your Honor.
It worked.
Well, it did work, Your Honor. And that's
You saying it did work?
it did work. There is no evidence in the record that any witness says that the cement was defective or didn't do its job.
In other words, the cement was not the cause of the lady's problem.
Dr. Randall, the explanting surgeon, the revising surgeon who did the second operation, he's the only one who was there in the joint seeing what was there to be seen. He never testified that the cement failed. He never testified that there was a defect in the cement. And what he did say, and this is quoted in the district court's opinion very carefully, the district court said, Dr. Randall said he simply did not know what caused the device to loosen. And loosening, both of the doctors clearly testified that it is a known, it's a relatively...
Was it related to the cement, or was it not? He did not even know whether it was related to the cement.
Nobody knows. Dr. Randall gave, I think, 4 different reasons that the loosening could have occurred. In none of those reasons did he say that it was a defect in the cement. He talked about osteoporosis, he talked about diabetes, he talked about some improper movements by the person who has the device. He talked about a variety of things that can cause...
His testimony essentially was it may have been related to the cement, or it may not have.
No. I don't think he went that far to say that it may have been related to the cement. I think what he said is, I don't want to speculate. I don't know. There isn't any evidence that the cement was defective, and I can't tell you why the device loosened. You know, to me, it goes directly to your opinion in Grenier. Why was there a silicon bleed? Wasn't related to any defect because the plaintiff never proved a defect. And without proof of a defect, redhibition fails every single time. And that's the case here. If you look at bedrock law in Louisiana, says that you cannot presume a defect from the fact that an accident occurred. You go to the Bro versus Centrifuge case, Judge Vance's case, the Porter case, Lawson versus Mitsubishi. Every one of them expressly and firmly say that you cannot presume a defect from the fact of an accident. And that's what's going on here.
Counsel, what about, and I don't want to get caught up in the terminology, but wasn't there an inference given in the Marinos versus Lake Charles Catholic High Schools case, Louisiana Supreme Court?
I don't read it that way, Your Honor. That was the case with the air conditioner that failed. And what they found that the plaintiff had proved through circumstantial evidence that there was a defect. They found a variety of broken parts in the air conditioner, that one broken part apparently led to 6 other broken parts, and the testimony was that that only happens in the presence of a mechanical defect. So while circumstantial evidence is appropriate in the right case to prove a defect, there is no circumstantial evidence here that shows a defect. You have to presume from the fact of an accident or an occurrence a defect. And the law doesn't allow that.
And to be clear, you're not arguing to this panel, and you did not argue to the district court that expert testimony is required by the plaintiff. Is that a fair statement?
To prove a defect, it is not. But Judge Doty wrote, and we agree, expert testimony is required to prove the second part of plaintiff's case, causation. You've got to prove first that there is a defect, and then that the defect caused the injury. And for that second part, in a medical device case, yes, expert testimony is required. I think the case there is the Redden case, Redden versus Medtronic, where the court said, in a medical device case, you've got to have expert testimony to link a defect to the cause of the injury, because there are so many reasons why things can go wrong in a medical device case. The very reason that doctors do not guarantee the result of the surgery. Nobody can. Counsel's reading of redhibition would essentially make the manufacturer of a medical device the insurer that the operation is going to proceed successfully. And that's not what the law is. It never has been in Louisiana, and it ought not be. First, counsel is incorrect that he could not have brought an action under the LPLA. The cases are replete with LPLA actions for medical devices. The cases are cited here. Many times you have both an LPLA claim and a redhibition claim.
I understood what he was saying was he had been thrown into federal court.
Oh, I didn't catch that part. Sorry, Your Honor. That he might be in federal court rather than state court, but he's in federal court anyway.
You're saying it's not preempted?
It would be preempted for a device that had FDA approval, which is a different process than the 510K process, which is less than the approval. Here, the rotating platform knee was approved. That would be preempted. But for the cement and for the other parts of this case, there's no preemption here. So you absolutely could have brought an LPLA claim. And the problem with bringing a case on...
Would you have been better off to have done that?
No, because there's still no evidence of defect. Under the LPLA, you must prove a defect. There is a total absence, a vacuum of evidence here that this device, this cement, was defective. Dr. Tretton still uses it. He is the implanting surgeon. The explanting surgeon said, you know, I was there. He saw no evidence that this was a defective product. And without any evidence of a defect, plaintiffs simply can't go forward.
I mean, his argument is essentially it obviously was defective because it didn't work.
Right. Let's take a look at where that would lead us. If, in fact, a medical device like a knee or a hip that requires the use of cement, which is not a glue, it's a grout. I think footnote 2 of our opinion talks about that. It has no adhesive quality. It's simply there to keep things in place. Like the grout for your tiles in the bathroom, it's not, this isn't important, but it's not an adhesive. So if a medical device is implanted using this and it separates, there are a variety of reasons why the device can separate. And Dr. Randall talked about it, Dr. Tretton talked about it, and neither of them said that the reason in this case was a defect. Dr. Tretton, who did the initial surgery, said, I warn and tell all of my patients that loosening is a potential reason for your device to be revised. You might have to get another surgery. It is something that happens. It happens for a variety of reasons, and there's just no evidence that this batch, this single batch of bone cement that has been used and on the market for decades was somehow defective. All the plaintiff is saying is she had a revision, it was a loosening, you must presume that there is a defect. And that's not the law. And I challenge him to quote any Louisiana case that has ever said that you don't have to prove a defect in retribution.
I think your illustration of grout holding together tiles in the bathroom is fairly graphic to the problem. I mean,
Pardon me, sir?
I'm just saying, it illustrates the problem here, and that is that the grout is not necessarily defective if the tile becomes loose in the body.
Yes, Your Honor, and of course in the human body there are a variety of things that can go haywire and cause a device to be loosened. This isn't in the record, and I hesitate to say it, but loosening is the most common cause of revision for a knee device after a device has been implanted for over a year. It simply happens, and I think Dr. Tretton said, and we've quoted it in our briefing, loosening is a known and expected risk of every knee surgery. And he said, yes. Well, a known and expected risk, this is going to the hidden defect issue, which I'm not sure we need to go to. The causation and the lack of defect should take us where we need to be. But this isn't hidden. Dr. Tretton certainly knew about the potential for loosening. He warned the plaintiff about the potential for loosening. Dr. Randall said the same thing, that loosening is a common, known, and expected cause of revision in the absence of a defect. In the absence of a defect. If plaintiff had a case where loosening only happens if the product is defective, then we've got a problem. But the evidence is exactly to the contrary. Every surgeon in this case says it happens without defect. It happens without surgeon error. It happens without the plaintiff doing anything wrong. But it happens, and it's warned about. And I feel like I'm saying the same thing over and over again, but the issue here, we really cannot go from the fact of a revision or the fact of an accident to a presumption of a defect. There is nothing in Louisiana law that allows that. And we would ask that you uphold the district court's opinion. Thank you, Your Honors.
Mr. Sarver, Mr. Wilson for rebuttal.
Yes, sir, thank you. First, let me quickly apologize to the court, comparing myself to my colleague. I'm very hard of hearing, in case you haven't noticed. And sometimes I think if I can't hear you, you can't hear me, so I talk louder. And I may have, I don't know that I did, but I may have raised my voice during my argument, and if I did, I apologize.
No, you did not, and you're doing fine, thank you.
Thank you. With regard to the evidence of a defect, on page 2 of my reply brief, there is a quote from Dr. Randall, and I'm going to read you the quote. Question: so the reason you can't medically say, you just can't say why the glue didn't work. We just know it didn't work. Dr. Randall replies, well, the glue worked on the bone, but the glue didn't work on the implant. Question: and it is supposed to work on the implant. Answer: we don't have. Well, yeah, it's supposed to. The thing is, you just don't know if the glue never stuck to the implant to start with, or at any point in the process that the glue came off. I wish I could tell you why that cement did not attach or stay attached, because you don't know if it happened immediately or later, why it was not attached or stayed attached. Question: we don't know why it came unattached, but we know it was supposed to stay attached. Answer: correct. The glue didn't work.
But that is not proof of a defect.
No, sir, that is not proof of a defect. That is circumstantial evidence of a defect, which gives rise to a presumption. Let's not forget, we're talking about summary judgment. We're not talking about a trial.
Now, I have some question about whether the mere fact that something doesn't work gives rise to the presumption of a defect.
Your Honor, let me refer you to a case from the Middle District, which was decided in 2021 by Judge Jackson. And he said in part, proof of a redhibitory defect may be made by direct or circumstantial evidence which gives rise to a reasonable inference that the defect existed. The buyer need not prove the underlying cause of the defect, but only that it existed. In other words, unlike a claim pursuant to the LPLA, the buyer can show that the product was defective without being required to prove the exact or underlying cause for its malfunction. That case was decided last year in the Middle District. It concisely sets out.
What are you quoting from there?
Yeah, that is Chisholm versus Mercedes-Benz. I've got a Westlaw site, but it was 1800661 in the Middle District. Judge Jackson decided it. And he quotes in his opinion all of the cases I've cited in my brief. That is a very concise statement of the law. Proof of a defect is not, you don't have to prove why the glue failed in a contract case as opposed to an LPLA case. If the plaintiff proves that the object of the sale failed in normal use and there is no allegation of intervening cause, intervening force, misuse, or abuse, if it failed in normal use, it creates a presumption that it failed because of a manufacturer's defect.
And what is your authority for that?
Young versus Ford, Your Honor.
If it doesn't work, there's a presumption of a defect.
Yes, sir.
What is your authority for that?
Young versus Ford is the case. Weber Manufacturing, written by Judge Tate, says the same thing.
a Louisiana court case or a federal court?
Those are Louisiana Supreme Court cases, Your Honor, both of them. One was written by Judge Tate when, before he came to this court. I'm out of time. The point I'm trying to make simply is that the failure of the glue creates a presumption that it was defective. It may not be, they may prove that they may outprove
What
it.
you're saying, if what you just said is true, you win
That's right.
in terms of getting it back overruled with summary judgment.
Yes, sir.
But if there is no authority for the proposition that you said, no credible authority for that simple proposition, you lose.
Yes, sir. If what I'm saying is not true,
I got it.
Thank you very much.
Thank you, Mr. Wilson. Your case is under submission.
I appreciate it.